Will now ask counsel on 126-279, the state of Kansas versus Dvonte Jamal Brown. Please come forward.
Good morning, may it please the court. I'm Ryan Edgar, Assistant Appellate Defender, appearing on behalf of the appellant Dvonte Brown. With the court's permission, I would like to reserve 3 minutes for rebuttal, please.
3 minutes is reserved.
Thank you, Your Honor. Johnson County jury convicted my client, Mr. Brown, of 1 count of felony murder with the predicate underlying felony being the distribution of marijuana, and a 2nd count of attempted 2nd-degree murder. The issue that I would really like to focus on this morning before the court is the first issue raised in our appellate brief. Of course, if the court has questions regarding the remaining issues, I would be happy to address those as well. What we've argued in the first issue is that the evidence of distribution of marijuana was insufficient to support the conviction for felony murder. Broke that down into basically 3 components, and I can just go through those in order for the court. The first component is that we've argued that under the Kansas Criminal Code, the state was required to prove that the substance that my client possessed at the time that he arrived at the Johnson County Public Library that night to meet with the 2 buyers in this case was in fact, the illicit version of marijuana. And I arrived at that argument because there's evidence in the record that comes from the state's own eyewitness to this offense, the only person to be in the car with Mr. Brown that night. And he brought it up sort of, this was his testimony, that he didn't necessarily 100% believe that the marijuana Mr. Brown had was actually the kind of marijuana that he was looking to get his hands on in order to get high. As the court's well aware, there are forms now of cannabis that are not criminalized under the code. And my client was charged with possession under the statute that requires it to have that component of the Delta-9 tetrahydrocannabinoid. So I think that when that testimony is reviewed, no reasonable juror is going to hear from the person who was actually purchasing it, who stands up and testifies, I didn't really believe that this was necessarily the real deal. And I think if we zoom out from that and take a look at the entire global picture here, this was a situation where nobody that was involved in this supposed transaction was honest. They were all, this was all a ruse from both parties, I would argue. It looks like from, I guess, circumstantial evidence from my standpoint and my client would be that he never, as soon as the money was shown in that car, he reached out and snatched it from him. He wasn't there to transfer marijuana.
Let me get to the basics here. Let's start with the statute. So 21-5705 says you cannot distribute or possess with intent to distribute marijuana. That's under A4, right?
Mm-hmm.
Schedule 1, that's a Schedule 1 substance, marijuana. So in that statute, it just says marijuana, one word. It doesn't say marijuana with THC. It doesn't, there's no THC or whatever that long word is that, that you did so great in doing. Okay. And then when we go to the definitions at 21-5701, there is a definition of marijuana. It means all varieties of the plant cannabis, whether growing or not, the seeds, the resin, compound, all that stuff. Nowhere does it say it has to have THC, correct?
I thought in that description, there's those 2 statutes read together. I would say that it does have to have that Delta-9 tetrahydrocannabinoid.
Why?
Well, because that's the active ingredient that is later when there's it's carved out an exception for not being illicit cannabis, then that's what's excluded.
Where does it say that in the statute? It says marijuana does not include the mature stalks of the plant, any Schedule 2, which is basically, well, I don't remember what that is, 2 through 5, okay?
Right.
Drug products approved by the FDA, CBD, or,
And I think that's where we're at, is the CBD component, which.
so marijuana does not include CBD.
Right, which is what I was.
Would you have something that had CBD, and THC?
I'm not sure. I think that in small quantities, all I know is that it cannot have THC above, I think, the CBD and the hemp provisions that are excluded. It's like 0.03%.
Right, but that's industrial hemp
Right.
for commercial, it's under the commercial
It's under the
industrial
commercial.
hemp. I just don't see, when you read these two statutes together, they don't even mention THC.
No, I don't think that they necessarily might mention THC.
And when
but
you look
it's-
at the cross-examination of the defendant here, I mean, that's what he said. They just focused on, well, did you, it didn't have the crystallized thing.
Right.
Something
He
about.
testified that
Yeah,
he didn't think he thought it was fake, essentially. It was not real marijuana.
Well, he didn't say that. I mean, that.
He said he did, and he said volume 81, page 87 didn't quite look like it. And there's testimony from 77 through 79. He testifies a couple of times and states that I didn't think the marijuana, I had belief that this wasn't real marijuana. Now, whether we want to dive into the actual, like what it, try to unravel what it is.
He said the real deal. And I mean, it was
The real
all
deal, right.
questions. He answered yes and no.
Yeah, he did
Yeah,
say,
I
I
mean-
didn't think it quite looked like it. He also said it didn't, like he said, it didn't look crystally. So be that as it may, he's testifying that whatever he's being presented with, he didn't think was actually marijuana. So that's the crux of my argument on the point of possession. Even if the court disagrees that in fact he did have marijuana, my client did have marijuana, then we still have to get to the idea of whether he intended to distribute
Okay,
marijuana.
but just getting back to this marijuana. Okay, so although RB admitted he was not sure whether the substance was real marijuana containing THC.
Right.
Okay, that to them, that was real marijuana contains THC. That's what I got out of that
Can I
exchange.
clarify something with you?
I'm sorry?
When you say with them, according to them, do you mean the prospective buyers or my client?
Although RB admitted he was not
Okay.
sure.
Yeah, okay. The prospective buyer. You was
The
not sure.
prospective buyer, oh,
Right,
sorry,
Right.
yeah.
No, I understand now.
Was real marijuana and agreed that it could have been fake. He testified that it looked like marijuana based on its appearance and smell. And the jury was left to weigh that conflicting evidence. And we look at the light in the most favorable to the state, right?
Correct.
So there was evidence.
There was some evidence.
And we can't reweigh this back and forth,
And
he said on direct.
That's honestly, that's fine. That's the first component of my argument.
Oh.
I don't want to get this bogged down so much. And unless, I don't mean to like.
No, go right ahead. I thought that was the main gist of it.
No, the main gist of my argument really is just that there was even if it was marijuana,
Mhm.
there's no intent to distribute here. And that I get to by the simple fact of, this was all a ruse. Even in the state's brief, it says that the two prospective buyers in this case admitted that it was a ruse. The state said it was a ruse. There was no intent to distribute marijuana here. The whole intent was to commit a robbery by both parties. And that's what's so puzzling about the outcome in this
And
case.
what would he have gotten from the robbery?
Marijuana. Well, what he thought was going to be marijuana. And that's the whole point of my argument is really, okay, first of all, there's a big question of whether it was marijuana at all. And that came from the person who was supposedly trying to buy it. But another huge component about this is the question of an intent to distribute. And what I've argued in the brief is that there's no intent to distribute here. The intent from the prospective buyers was not to distribute marijuana, it was to steal marijuana. And it was also to steal marijuana that they testified for their own personal use to smoke it.
But why
And-
isn't that an attempt to transfer, which
Right.
the statute includes?
Well, under this
under
court's
the word
precedent,
distribute?
but fair enough. And under this court's precedent in Mora, where two parties are going to purchase marijuana in order to smoke it themselves, that was held not to be distribution.
How much marijuana was there?
It was, I want to say 4 ounces between two people would have been the two prospective buyers in this cases.
4 ounce. Why was I thinking something about pounds?
No, it was a quarter pound. That's probably because pound, quarter pound, and
Okay.
you were thinking pounds, but what's that?
I don't,
16 ounce, so 4 ounces. So that's between two people. And so the prospective buyers, at least under Mora, legally weren't going to distribute marijuana when that aren't distributing marijuana. It's clear that my client wasn't distributing marijuana. He went also under a ruse. I'd say based on, I mean, it's hard to distill. There's no direct evidence of what his intent is, but I think we can see from what happened, what he was planning to do. So both parties are there not to distribute marijuana. None of them are being honest. They're there to both rob each other. And it's so, they're charging the alternative here. And it's really puzzling that the verdict came down the way it did. Frankly, as I'm reading through this, I was expecting to be stuck in a possible merger situation. But the jury found that it was distribution. And there's no substantial evidence. There's just no evidence, sufficient evidence that this was distribution. It was a robbery.
not his own statement that he went there to sell the marijuana. I mean, even if it was a
Whose
lie,
statement?
what, it wasn't that what your client? Isn't that how your client described what was happening? Is that he was offering to sell? Or am I misreading something?
He was
I don't
purchasing.
think so.
Okay,
I'm sorry if I can check on that during rebuttal. But
okay, no, I'm probably just misreading and getting the names. Sorry.
yeah. But that is the crux of my argument, that this isn't a distribution, and and furthermore, this killing.
What is the statutory presumption for distribution of marijuana under the criminal code? It's in grams, so I don't know how to convert that.
I'm
Maybe
not
off
sure.
the
I
top of my
haven't.
head.
I'd have to look at what the
So like 450, I think 450 grams.
450 grams. What is 28 times 4? I think it's somewhat under. I think it's just over a quarter pound. So I don't
Okay.
think we've gotten to the statutory presumption yet, and I don't think that was ever brought up in any way at trial either. Obviously, that is what happened here. And as far as any sort of distribution, even if the court finds it was distribution, that distribution had ended by the time the killing occurred. So the criminal offense was, if it was distribution, furthermore, it was over at the time the killing occurred, because my client took the money from the buyer, said, "Get out of my car before I shoot both of you." And that's at the point that the brother comes in and starts wailing on my client. And that's when the shooting occurred. I don't know if the court has any additional questions for me at this time, but I think that's pretty much summation of my first issue. Thank you.
Thank you. Mr. Obermeyer?
Madam Chief Justice, and may it please the court, I'll begin by just giving sort of an overview of the case, some of the facts, because I think there's some confusion as to who did what when. The protagonist in this case, the victim who survived, RB, was a minor who in Johnson County Juvenile Court had been released pending from custody, pending entry into a rehab facility on April 8th. So the last night of his ostensible liberty, he decides he wants to get high one more time. And so he enlists his older brother, who's actually an adult, MB, to help him get some marijuana. Now, they don't have any intent to pay for this marijuana.
Oh,
although
and I'll just interrupt you just for my own. In the last exchange I had with defense counsel, I had thought that defendant was the one who was purportedly selling the marijuana.
correct.
And okay, so I was correct about that.
Yes.
And okay.
That is, yes, Justice Steele, you're correct on that. They search for a plug. That's the word specifically they use. They're looking for a plug, someone who sells drugs, someone who can get them drugs. And through a friend that RB has, he gets the number of the defendant. And there's some messages exchanged between them, and there's a deal struck between them for $500. The brothers will give $500 in exchange for a QP, a quarter pound or 4 ounces of marijuana for them. So it's the defendant who's the one doing the distributing in this. It's not RB or MB. To effectuate this robbery, they just intend to snatch and grab, according to RB, and just sort of run away. But RB takes with him a steak knife from his mom's kitchen for protection. They proceed to a library in Johnson County, Kansas. They're waiting in the parking lot. The defendant arrives later, and RB goes inside of the defendant's vehicle. The defendant shows him 2 quart-size or 2 gallon-size bags full of marijuana, and then he hands RB a nugget of what he says is marijuana. He says it looked right, it smelled right, it seemed to him like it was marijuana from the trial transcript. And as counsel noted, defense counsel on cross-examination did an effective job, I concede, of trying to sow doubt in the jury's mind that this was not in fact marijuana. Well, the the drug deal goes wrong, as drug deals so often do, and the defendant is the one that snatches the money from RB. The brother sees that this has happened. He goes to the defendant and begins hitting him with his fists. At that point, the defendant produces a firearm, perhaps 2, and then shoots MB repeatedly, killing him from that. The defendant then drives off and then comes back trying to kill him. That was, I believe, RB's testimony. It's also borne out on the surveillance footage as well, that his vehicle returns repeatedly to the scene before police arrive. RB is the one that calls 911, and he cooperates with police, telling them, this is what happened. We were trying to rob someone. My brother died. So he does not paint himself in any good light. RB's testimony, he gives the good, the bad, and the ugly in this whole situation. Police are able to connect the defendant. They're able to identify him with the phone number, with the some blood on the knife that RB had. He was able to get the defendant at a certain point when he sees that his brother's in trouble. And there's blood on the knife, and the DNA report essentially says that this is the defendant. So all of that is sort of summary of what happened, how this came to be.
Where was the marijuana ever seized by law enforcement?
No, Justice Rosen. The marijuana was never seized. The defendant drove away on the night in question. His vehicle was found in Kansas City, Kansas, I believe. It was burned out. There was really no evidence of drugs that they could or did recover from that, although there was evidence of ownership. So the state's argument then and now is that, you know, any evidence was gotten rid of, it was destroyed. And I think there was a span of 2 days and some hours from the time when MB was murdered to the time when the defendant was identified and presented himself to police. He did turn himself in upon request. So there was no chemical testing. There was no drug testing of any marijuana. There was no factual question as to whether or not this was Delta 9, CBD, or something else. The evidence which the state relies upon to support distribution of marijuana is the impressions of RB, that it seemed right to him. The deal was arranged for marijuana. That was the intent of the parties in coming to this location. And it was at night. I will state that as well. There's no reason for them to be here except to effectuate a drug deal. The question then is to whether or not this occurs within the res gestae of the crime and whether or not there is a causal connection between the two. So res gestae of the crime being in, it's in the same sort of, so associate, it's before, during, or after the crime, and so related in time, place, and relationship as to form part of the occurrence. And this indeed is one of those situations where the drug deal goes wrong, the intent of the parties changes at some point, and someone dies in the course of it. I think I'll disagree slightly with counsel as to the intentions of the defendant when he came there. I think it's a fair reading of the evidence that he had every reason to believe that this was a legitimate drug deal, perhaps, and he changed his mind that he wanted to do a fair drug deal when he perhaps sees RB, who is a juvenile. The defendant is an adult, obviously. He probably thinks that this is an easy mark. So I think that probably it's a fair reading of the evidence that the defendant, if RB is to believe that, you know, the money snatched from him, that intent sort of developed during the course of the.
Am I understanding the facts correctly, that the evidence supports the notion that whatever the intent of the defendant was, there was one point at which he, I'll say, proffered a sample to the victims?
Yes.
So that was a physical transfer of the substance, which was testified to be marijuana.
Yes, there was that physical nugget that Roman Babic testified to that he believed was marijuana, but yes, he also conceded he had questions.
So even if we credited the defendant's argument that the intent of the defendant all along was to commit a robbery and essentially take back all the marijuana, there was, at a minimum, there was that physical transfer of the product, even if it was a bait, let's say.
Yes, that is literally true, based on the testimony of of RB. I think I'll rest on the brief as it relates to most of the issues, but I do think that issue 5 is an interesting, it presents an interesting question before the court as to whether or not RB's testimony was so extraordinary as to whether or not it could even be believed, based on this court's now 50-year-old holding in State v. Matlock. I would ask this opportunity, I ask the court to take the opportunity to overrule the Matlock case. It has in the past described it as an anomaly. Essentially, the facts of Matlock, a rape conviction was overturned in the assessment, and a 4-3 decision was that the victim was so inconsistent, so unbelievable that no rational jury could have convicted based on that testimony. And that, as cited in the brief, that opinion does not appear to be based on Kansas case law. It appears to be based on Missouri, Oklahoma, other case law. And it's also inconsistent with this court's holdings that it is not a fact-finding court. That is up to the jury to decide credibility, to weigh testimony, to decide what in fact is believable and what's not. So, and it also has some outdated notions in it as well. Matlock specifically seems to focus on sexual crimes that for some reason victims in those cases are less credible than victims in other cases. So it's in contradiction. I think the court, you can make the argument that it's already overruled implicitly by the fact this court doesn't review evidence, that even the most serious offenses can be sustained by circumstantial evidence. So, but it still is somehow just out there. That concludes my prepared presentation. If there are any questions from the court, any clarifications I can make? Thank you.
Thank you.
May it please the court. If I could just touch on, I suppose, quickly what you're getting at, Justice Steele. There was a moment where, and I think I was just confused about, were you thinking that my client had testified in his own defense or something? But no, the only evidence of sort of that I guess we could glean his intent from would have been the text messages that were that RB gave up voluntarily of his phone between him and my client. The other part would then be that brief moment where he, you know.
Yeah, that- I mean, that-
Where he hands them and says, here's what I.
That was in our last exchange, kind of
That's
where
where
we
you're-
were, I was headed with
Okay,
in terms of what is the evidence of an intent to distribute.
okay.
And my question essentially is, why wasn't it enough that there was evidence that your client offered to sell? Even if it was a lie, he had offered to sell.
Right.
And then they were in the car and he proffers him a sample and he makes a physical transfer. Why isn't that enough?
Because I think intent means to do a specific purpose.
But even if you were intending to rob, I mean, he also intended to hand, I mean, as part of the robbery.
Robbery,
maybe,
I understand
But he's
that.
still distributing,
Yes,
right?
as part of the ruse of my
Yeah.
robbery, and I understand what you're getting at.
Isn't that enough?
Well, here's the thing though, under Mora, you have to look at what distribution means.
But I don't
And-
understand yet how Mora relates to this case.
Because you can't, I can't distribute to myself, right?
But he's not.
So
He's, even
he's
if it's a
not. He's
ruse.
distributing
he
it
just-
to, okay, let's just say that he's distributing it. Under Mora, that opinion holds that where two people are acquiring marijuana to share it amongst themselves, that's not distribution. They testified that that's what they were going to do with the.
That would
marijuana.
have to do with the
Right.
alleged distribution between the two victims, not between the purported seller and the buyer. Mora doesn't talk anything about that. It talks about sharing between friends when they purchase together.
After the distribution is completed, is that? Okay, well, then I've misunderstood more.
Okay.
Unless the court has any additional questions, I'll waive the remaining. Thank you.
Thank you. Thank you to both attorneys for their arguments in this matter. The court will take this under advisement.